may please, my lords, I appear in this matter with Mr. Stephen McGarry of Counsel on behalf of the appellants. My learned friend, Mr. Nicholas Vinyl, Queen's Counsel, and my learned friend, Mr. Adam Temple of Counsel, appear on behalf of the respondent, the Financial Conduct Authority. My lords, there are two appeals that are listed before your lordships today. The first appeal is against the orders that were made by Mr. Adam Johnson, Queen's Counsel, as he then was, who was sitting as a Deputy Judge of the High Court on the 14th of July 2020. That amounted to a series of declarations, and it followed a trial. Which
we're very familiar with the background, Mr. Barclay.
I'm very grateful for that indication. So perhaps I can come to that your lordships will be aware of what the nature of those declarations were, and will know that the background to this relates to the regulation within the Financial Services Markets Act 2000 and the prohibition that appears within Section 19, the general prohibition in relation to...
Can I just stop you for a second and ask you two questions? First of all, is a transcript of this hearing being prepared or not? The answer is obviously not.
Well, the answer isn't that I don't know.
Well, I see Mr. Vinyl shaking his head, so it looks to me...
I think we would know if it were,
exactly.
And we don't know that it is.
No,
so
perfect. Well, that's just for our personal knowledge. And the second thing is, have you agreed with Mr. Vinyl the distribution of submissions?
What we've agreed is, what I've indicated when I've friend and I think he's happy with is the sequencing of submissions.
Yes, the sequence, but also timing. Because obviously we have 2 days for the appeal. We hope that won't be necessary, but we'd like to have some idea about how long you're going to be, and then how long Mr. Vinyl's going to be.
My learned friend suggested to me that he might be up to half a day, in which case we'll have no difficulty
at all. Well, that's fine. Yes.
And the truth is, as long as he finishes today, I won't need more than half a day tomorrow at the outside, I think.
Very good. Thank you very much.
Reply.
That's good. And the other thing is this, that as regards the applications before us, namely the application for permission to advance new grounds of appeal, we would like you to deal with those on the basis that
yes.
you have permission
yes.
or might get permission, and we will deal with the question of permission and also the grounds substantively, if appropriate, in our judgments in due course. So there'll be no need to have back and forth. You can deal with everything in opening, Mr. Vinyl can respond to everything, and you can reply to everything. And as regards the unagreed bundles, feel free to take us to any parts of the unagreed bundles that you think appropriate, and we will look at them to bene esse and then decide again in our judgments whether we need to see them.
I'm very grateful, my lord. Can I therefore indicate that what I intend to do then is that I intend first to advance my submissions in the first appeal.
Sorry, you intend to?
I intend first, sequencing
yes.
I intend to adopt is this, that I intend first to advance the submissions on the first appeal upon those grounds upon which permission was granted by Lady Justice Aspler.
Yes.
I will then turn to the additional grounds, and I will address the issues of jurisdiction and delay, and then develop my arguments on those grounds so that your lordships are able, as your lordship say, to determine the application and deal substantively with those if necessary.
Yeah.
And then finally, I'll turn to the second appeal. And the success of the second appeal is to some extent, and is at present, limited to being consequential to the outcome of the first appeal.
Yes.
But I will make some observations, particularly about the effect of your lordship's, the court's decision in Adams on the issue of interim restitution orders.
Yes. Could you try and keep your voice up a bit, Mr. Barclay? It's there's always a bit of noise outside, and the louder you speak, the more chance we have of hearing you.
I'm very grateful. Your Lordships have indicated that that Your Lordships are familiar with the background of this case, but I think that it's just important that I at least set out the background for the purposes of looking then at the framework, the statutory framework, which we'll have to look at in my submission.
Yes, of course. You take your own course. I'm just urging you not to give us sort of lengthy introductions to names and numbers which we know.
No. In fact, what I'll do is if I can present it almost so that the contours are clear without having to deal with the great detail. So, if your Lordships will indulge me, so your Lordships will know that what concerned with two companies, Avacade Ltd and then Alexandria Associates UK Ltd, which was also trading as Avacade, and those two companies successively from 2010 to 2016 carried out activities which were directed at individual pension holders. And they did that by various means, principally by telephone and a team of people who were using information they had about people's pension data so that they were able to access people. And that was the model, with various variations. The second and third appellants are father and son, and they were directors of the two Avacade companies. There was another man called Mr. Fox, who was a director of the first Avacade company, Avacade Ltd. And he hasn't appealed against the orders made by Mr. Adam Johnson. Your Lordships will know that in many, many cases, but not all cases, pension holders moved their pensions from occupational pension schemes into self-invested personal pensions, or SIPs. And having done so, having taken that step, they then, in most cases, purchased products. Most of those products were what we'd call unregulated investments, such as the purchase of trees and so forth. Although there have been, and there were examples, particularly in the later model and under the first appellant, where there was also the purchase of bonds. But the overwhelming majority of the transactions at the investment stage within the SIP related to unregulated products.
And when you purchase a tree in a foreign country, are you purchasing the tree or the ground on which the tree grows?
Well, I think typically you were purchasing saplings.
Does that make a difference to the answer?
That's often how they're described. I'm not sure, particularly as these were trees purchased in countries under different jurisdictions in relation to law of property. I don't think that I have.
Okay, well, if you don't know, you don't know.
I don't know the answer.
But it's the purchase of the property itself. It's not the purchase of shares in ethical or blended plantation.
That's right. That's right. And those transactions, the purchase of trees and so forth, that was in general how the Avacade companies derived its financial benefits, because it's from those sales rather than from the movement of funds into the SIP that remuneration was earned. And the evidence suggests that commissions in excess of £10 million were earned by the Avacade companies.
But that's not all they got, is it? There were commissions for the first transaction.
There were some commissions.
Smaller commissions.
But they were smaller, and in terms of scale, they represented a minor element of this. And the investments themselves, as your lordship would know, were not successful, and it can be assumed, for purposes of the appeal, that there were considerable investor losses. So that led to the Financial Conduct Authority issuing the present claim on the 6th of September 2016. And the allegation was that the Avacade companies, which were not authorised persons, had contravened the general prohibition in Section 19 of the Financial Services Markets Act 2000 because their activities included regulated activities. And in addition, they alleged other contraventions, such as the making of financial promotions, contrary to Section 21, false and misleading statements, contrary to Section 397 of the Act, and they alleged also that the second and third appellants and Mr. Fox, who were the directors, had been knowingly concerned in the contraventions. And the judge found, after hearing trial which lasted some 10 days, and having reserved his judgment and handed down a detailed written judgment, that the Avacade companies had indeed committed those wrongs and that the directors had been knowingly concerned. And on the 10th of August 2020, Mr. Houseman, Queen's Counsel, sitting as a Deputy Judge of the High Court, made interim restitution orders under powers under Section 382, subsection 2 of the Act, which included orders that the first appellant pay £715,000 and that the second and third appellants each pay £2.5 million. And he ordered that the cumulative total which the respondents could recover would be limited to £10,715,000. And he also made other orders, including injunction orders. On the 4th of August 2020...
I'm sorry to interrupt you. You refer to the first appellant?
Yes, Avacade, Alexandria Associates.
Yes, thank you.
So just, I mean, it's more helpful to me to refer to the people you're talking about. So could we call Craig Loomis Craig, Lee Loomis Lee, AA, and Avacade.
Yes.
And if we do that, and Mr. Fox, and then
yes,
we'll be absolutely clear who we're talking about.
Certainly. So,
and just so I've understood it, there's no appeal by Avacade, but the reason we're
yes,
concerned with whether Avacade was in contravention is because Craig and Lee are appealing, and the question is whether they were knowingly concerned in the contraventions by Avacade.
That's absolutely right, my lord. So the position, there is no appeal again by Avacade. Avacade Ltd was in liquidation and didn't really take part in the trial and hasn't appealed the order. Mr. Fox didn't participate at the trial, but he hasn't sought to appeal the orders. And absolutely right, AA, which is a company still under the control of Craig and Lee, has appealed, and again, it may be an indication. I mean, just providing an indication. You also will see that the order, the interim order made in relation to AA, is significantly smaller than the order that was made against Avacade Limited, and that reflects the scale. And then each of Craig and Lee Loomis were ordered to pay £2.5 million.
And that stayed pending the outcome of this appeal.
It has been stayed pending the outcome of this appeal. So on the 4th of August 2020, these appellants issued their appellant's notice in the first appeal. And if I can invite your lordships just to go to the agreed bundle and to page 11.
11.
Yes, 11.
Are you using electronic numbers or?
Well, I'm using the pagination. I'm not sure whether this.
Okay, that's fine, just so long as I know.
I'm using the pagination in the physical copy that I've got in front of me.
Yeah, that's the grounds of appeal.
That's the grounds of appeal.
It's electronic page 14. In fact,
very helpful.
the pages are out of kilter, but my lord and I will probably manage to deal with that.
I don't know whether my lord is in a better position than I am. I thank you for the electronic bundles. Mine are not in OCR form, so they can't be cut and pasted from, and I've had to make my own bookmarks. And surely by now we're in a position where we can actually produce working electronic bundles.
Yes, I've certainly noted, and by those who are sitting beside me.
Thank you. Also, while I'm at it, it ought not be beyond the wit of man to produce electronic bundles that have the same pagination number as paper bundles. But we're 3 apart, which is not the worst, I think.
Well, unfortunately, in the supplemental bundle, we're many more apart. But yes, it ought not. I echo what my lord has said, and it would be very helpful if those matters were attended to at some point, maybe not in this case.
Yes, well, I'm sure that those in court will reflect on that, and I'm grateful for what your lordships have indicated.
I mean, people should know who appear in these courts that many of the judges are entirely free of the use of paper. So if counsel wishes to use paper, that's fine, but they have to realise that the court does not. In many cases, not all cases, my lord uses paper, but I, for one, don't.
Yes, I know, and I think that for many of us, we're still on a learning curve.
Yes, good. Keep learning, Mr. Bartley.
Yes.
On you go. We're looking at the grounds of appeal.
Yes, we are.
We blew you off course, for which we apologise.
When the matter was considered by Lady Justice Asplin on paper, she granted permission to appeal, which was limited to ground 1, ground 2, and ground 3.
And ground 9.
And I'm going to come to that, and ground 9. But just ground 1, 2, and 3 are clustered around the principle of the regulated activity of making arrangements.
Yeah.
And as your lordship pointed out, she also granted permission in relation to ground 9, which relates to one of the statutory exceptions, Article 33. Similarly, a notice of appeal was issued in relation to Mr. Houseman's order, and that relied upon 14 grounds of appeal, and you'll see that at page 30 using the pagination. In respect of this appeal, the second appeal, permission was granted by Lady Justice Asplin only in respect of ground 1, which, as pointed out, is purely an application which depends for its success on the outcome of the first appeal. Your lordships would have seen from the judgment of Mr. Adam Johnson that he was referred to, or he referred to the first instance decision of His Honour Judge Dyte in the case of Adams and Options UK Personal Pensions LLP. And an appeal from Judge Dyte's decision came before Your Lordship's court, and judgment was handed down on the 1st of April 2021. And both parties to these appeals recognise that the decision of Your Lordship's court in Adams is relevant, not least because, in one significant respect, the Court of Appeal departed from the judge's analysis in Avacade and held that the purchase of unregulated assets such as trees from funds within a SIP does not involve the buying or selling of securities. And so I think it is acknowledged and recognised by the respondents that making arrangements for or advising upon the purchase of, say, trees is not itself a regulated activity. And the appellants seek to rely upon Adams in support of their application to rely upon the additional grounds, including...
But does the analysis in Adams not actually lead to the conclusion that it's not a regulated activity to make arrangements for buying anything within a SIP because of the trust nature? Yes. Yes.
Yes, assets, whether they're regulated or not. But certainly, the fact that when we come to look at the analysis of the judge in this case and the way in which he segmented this into steps, we'll see that in the judgment. The purpose is now of considering what contraventions there have been, if any, by Avacade and AA. One's got to look at particularly step 2 in that analysis as well, in the course of the judgment. And for completeness, I should mention that the appellants, as Your Lordships know, attempted without success to obtain a stay of these appeals pending any determination of an appeal in Adams to the Supreme Court.
I mean, what was the point in that, Mr. Barclay? Because if Adams is right, then we have to deal with this appeal on the basis that Adams is right. And if Adams is wrong, it's even less likely or less likely. It doesn't help you if Adams is wrong. It can only hinder you. And so I couldn't understand why you were asking for a stay. I mean, there are two parameters you're going to have to get over. We may as well get them out in the open right away. When Lady Justice Aspin dealt with permission to appeal, Adams had not been decided by the Court of Appeal. The law was what it is, and by statute, permission to appeal is final. And that's the end of it, because there has to be finality in litigation. So if you wish us to reopen it on the basis that the law changed after you were refused permission to appeal, that is problematic for you. And I'm quite happy to hear submissions on that, but that's my current understanding. And the second point is that, as I say, Adams is relevant, and we have to take it into account because we're hearing the appeal for which you were given permission today.
Yes.
But you may say you should be allowed to make application to raise more issues for which you have not been refused permission already because of Adams. And we'll hear argument on that. But as I say, at the moment I can't understand why the appeal in Adams is likely to affect the outcome in this case. It's only going to make it worse for you. If you win, you'll still have won if Adams is wrong, and if you lose, you'll lose.
I hear what my Lord says. I mean, I'm not revisiting the issue of the application for the stay.
No, okay, you mentioned it.
Yes, I mentioned it for completeness, but you're just right that it may have been ambitious.
Yes.
So,
Because it might be ages, Mr. Bartley, before. I mean, that would be delaying these already much delayed proceedings for years, possibly. I mean, we know, with great respect to our colleagues in the Supreme Court, that they're not the fastest, always. It might be 2 years.
yes. Well, my lords, that's the what I intend to do now. And I know that these matters are likely to be familiar to your lordships, but it'll give me an opportunity, I think, to frame my submissions if I do it this way. If I take your lordships through the statutory framework itself.
Yep.
So can I take your lordship to paragraph 14, so page 14, I should say, in the authorities bundle. I don't know whether there's a lag in the bundling there.
It looks like it's 2 out.
So paragraph 14 should be section 19.
But did you say they're 2 out?
2 out, yes.
2 out.
Section 19 you want.
I'm looking at section 19 of the Financial Services Markets Act 2000.
Yep, that's on.
And that is the general prohibition that no person may carry out a regulated activity unless he is an authorised person. We're not concerned with exempt person. And that prohibition is what's referred to as the general prohibition. If one goes to focusing on the words regulated activity, as to what is a regulated activity, one can see that in section 22, page 17 in the bundle, that a regulated activity is an activity is a regulated activity for the purpose of the Act. It is an activity of a specified kind which is carried on by way of business and relates to an investment of a specified kind. And you'll see that in subsection 5, specified means specified in an order made by the Treasury. Before we go to the regulated activities order, which is where the order is to be found, made by the Treasury, just whilst we've got the Act, can I just draw your Lordship's attention to section 23, which appears at page 19. It does feature slightly in the in submissions that the contravention of the general prohibition produces a criminal sanction. So a person who contravenes the general prohibition is guilty of an offence.
Has there been a prosecution here?
There's no prosecution here, no. But the context is that the actus reus, if you like, of the contravention is also the basis upon which a prosecution is available, which gives rise to an offence punishable with imprisonment.
Subject to defence under 23.
I was going to come to that, and in fairness, I was going to then draw your Lordship's attention to the fact that that in subsection 3 there is a statutory defence to show that the accused person took all reasonable precautions. It's not, therefore, strict liability, but because there is, as has been pointed out, a statutory offence. And then since we're looking at the Act, it might also just be helpful to also draw attention to page 21, which is where we get the restitution orders. And if I can just draw your Lordship's attention to this, that the power to make the restitution order only arises if the court is satisfied that a person has contravened a relevant requirement or been knowingly concerned in the contravention of such requirement, and A, that profits have accrued to him as a result of the contravention, or B, that one or more persons have suffered loss or been otherwise adversely affected as a result of the contravention. And then subsection 2 sets out how the court may exercise its powers. It has to be just, having regard to, and as one might expect, the issue of the profits which have accrued and the extent of the loss which have occurred, or both. And then the payment is made, in this case, to the FCA, and they can distribute it. So that's the restitution order mechanism in the Act. Should also, because it features in this case, just draw attention also to section 397, which you'll find at page 24, which relates to making misleading statements. And that also features in the judgment and the declarations.
And this was in effect until, was it April 2013?
And then it was replaced by the Financial Services Act 2000. It was replaced
2012, section 89.
That's right. That's right.
That was with effect from April 2013, so it falls within the middle of our.
Yes, yes. It's simply a timing issue, and I don't think that anything of substance turns on that.
Thank you.
So I'd like to now just go to the Regulated Activities Order, the RAO, and again, because I think this is quite important in the context of the submissions I'm making, again, if you forgive me whilst I take your lordships through this, as we look at page 35, we can see the specified activities include arranging deals and investments. Arranging deals and investment under the heading activities is the habendum under which Article 25 appears. And Article 25(1) describes an activity of making arrangements. And Article 25(2) describes an activity of making arrangements. And it is necessary to consider each of those in turn. And I'm looking first, if I may, at 25(1), although in the context of this case, the specific contravention that was alleged, as opposed to say what was alleged in Adams, was an allegation of a contravention of 25(2).
Was there no allegation of contravention of 25(1) at any stage?
No, I don't think there was. And Mr. Varnell lived with this case longer than I did, but I don't think there was, in my recollection.
No, we put it as a 25(2) case.
Okay, thank you.
I'm grateful for that. So, if I can first look at 25(1), and that is making arrangements, and I'll just abbreviate it to what's the operative parts. It's making arrangements for another person to buy or sell a security. That's the specified kind of activity. And the definitions of buying and selling are set out, and you find those at page 28. You'll see the definition of buying. I don't think we really need to look closely at this, but I'll just draw attention to that. So buying includes acquiring for valuable consideration. And selling, you'll see at page 33. Bottom of 33. In relation to an investment, includes disposing of the investment for valuable consideration, and you'll see the disposing includes surrendering, assigning, and converting rights. And
For rights under a contract.
yes. And then, because the object of this has to be a security, for it to be a specified kind of activity, it's necessary to look at what security means, and that's immediately above selling. And security means any investment of the kind specified in Articles 76 to 82, or so far as relevant by an investment under Article 89. So can I just take it, or briefly, to page 79 in the bundle, which should be Article 82. I'm right. Yes. And your Lordships will see that rights, that one of the specified investments are rights under a personal pension scheme. And the case proceeded in the court below, and it's not being challenged here, that a SIP is for these purposes a personal pension scheme. I will suggest, again, because it's a small number of to which this relates, that Article 77 includes bonds as another specified investment. And you've seen references to occasions when there is the Paremba bond and such like, where there were bonds that were purchased rather than trees. And whilst I've been on my feet, I don't know whether this assists at all, and I don't know how much you can rely upon this as a statement, but I'm instructed that in answer to the question that was raised by, I think Vanessa Rose earlier, that the purchase was of trees rather than of the land upon which the trees were growing. So, if I can take your Lordships back now to page 35, back to Article 25, and now draw your Lordship's attention to making arrangements, which appears within Article 25(2). And there we have making arrangements with a view to a person who participates in the arrangements, buying or selling investments falling within paragraph 1A. That's also a specified kind of activity, says the draftsman. Draftsperson. It's fair to point out that, particularly when one looks at 25(2), that the reference to a view to a person who participates in the arrangements, buying or selling investments, that in the context of this case, and possibly many others, what's being said is that the arrangement, the person who participates in the arrangement, is a reference to the consumer investor. So it's making arrangements with a view to a person who participates in the arrangements, investor buying or selling investments, and that's also a specified kind of activity. So the Act contains, as well as defining what the regulated activities are, the Act also contains statutory exceptions or exclusions. And the one that I think we should look at now is 26, Article 26, which is at page 38, which specifically excludes from Article 25(1) arrangements which do not or would not bring about the transaction to which the arrangements relate. And that again is under addendum saying arrangements not causing a deal. And there's a further exclusion that's relevant to this ground of the appeal, grounds 1 to 3. And that is when one looks at Article 33 at page 44.
Just before we leave Article 26, does the fact that there is excluded from Article 25(1) arrangements which do not or would not bring about the transaction, does it follow from that that the definition of making arrangements in 25(1) would otherwise include cases where there was no deal?
Well, my Lord, if 26 was absent, and one was only looking at the 25(1) in isolation without that statutory exclusion, then in isolation I would still be submitting that in order for there to be an arrangement, it would have to be for the person to buy or sell security. But the word to buy or to sell might have suggested that the arrangement would give rise to the contravention, irrespective of whether the transaction was ultimately entered into. And it may be for that reason that we therefore have the specific exclusion in relation to 25(1), that what is excluded is arrangements which do not or would not bring about the transaction.
Well, I'd understand that if we didn't have the words would not in Article 26, which is a hypothetical.
Yes.
What's that directed to in terms of something which otherwise falls within Article 25?
Well, in my submission, if one regards that certainly for Article 25(1) there is a need for some causality, there's a need for there to be a causal nexus between the arrangements and the investment and the transaction. That where someone has entered into arrangements which, objectively speaking, would not themselves bring about the transaction, but the transaction does occur, but there's no causal nexus with the arrangements, then that would fall within the exception. So the exclusion has two savings. Well, one is when there's no deal, and the other one is whether even when there is a deal, the deal has not been brought about by the arrangements, because those arrangements would not in themselves have brought about the transaction.
Yes. And if that's the scope of the exclusion in Article 26, does it follow that without that exclusion, those would be included in 25(1)?
It's
Both no deal and no sufficient causative link.
The question is whether the draftsman intended to be looked at in such a hermetic manner, or whether this was a reinforcement. And for the purposes of my submissions, what I'm seeking to stress, and my submission that is consistent also with the authorities which we'll consider, is that certainly in 25(1) it's recognised that there has to be an element of causality between the making of the arrangements and the transaction. And
I understand that. You say that follows from 25(1) itself, not from the exclusion in 26.
That's right.
Right.
26 may be a reinforcement.
Thank you.
25(2) is concerned also with making arrangements, but on this occasion it's arrangements with a view to a person participating in the arrangement, in other words the investor, buying the investments, which have to be investments that fall within which have to be a security for these purposes. That's what we're dealing with. And that also is a specified activity. Now, having taken your lordships through that, it might be helpful now to look at how the judge in Avacade approached this, and to take your lordship to the judgment, which you will find page 137 is where it begins.
Sorry, did you say paragraph 100?
No, page 137 is where the judgment begins.
Yes. Could you give us paragraph numbers in the judgment? Some of us have it separately.
I'm going to do that. I'm going to do that. I just want to identify the judgment. I'm not going to take your lordships slavishly through this judgment, so I will provide your lordships with the relevant paragraph numbers as I go through, and also the page numbers, if that helps. So let me begin with page 158, paragraph 93. And he sets out there the steps that were taken in the Avacade model. I'm not inviting your lordships to read that closely, but clearly he's describing there several steps, and includes also the role of cherish in some cases in connection with some of the bonds, and that's an IFA, independent financial advisor, who in the event the judge found only carried out a very limited function in relation to risk assessment. And then similarly at page 145, sorry, page 166, paragraph 145. Similarly, the judge there sets out the steps that were taken under the AA model. And the AA model included the role of another IFA called Black Star, who was providing reports. And then paragraph 171 onwards, the judge sets out the statutory framework which we've been looking at.
I'm sorry to interrupt you. I don't know that this will be a convenient moment. You've just passed over paragraph 166.
Yes.
Speaking for myself, I just wanted to make sure I've understood what all the underlying investments were, because we've referred to the trees and the bonds, but
indeed,
we've got a list of them here.
it's helpful, yes.
And the hot pods were commercial office space, is that right?
That's right.
And what was the Mosaic Carib?
I think that was, again, I think saplings. Yeah.
That was the life policies. That was
yes.
the
Sorry.
In the BVI, were they?
I'm surprised, but I can't remember.
Right. Anyway, you can come back to us
I'll
on
come
that.
back to that. I'm sorry for not being able to answer that.
And then sustainable agro-energy was green oil from
Yes.
crops in Thailand, Cambodia
Yes.
and the Philippines.
Yes,
And ethical forestry were the Molina trees in Costa Rica.
indeed.
Global plantations were the teak trees in Malaysia or Sri Lanka, is that right?
Yes.
Then Invest US and REI USA were sequentially two different bonds
Yes.
securitizing US property. Is that
Yes.
right?
In the case of the certainly in the case of Invest US, it was securitizing property. In relation to the Paribas bond, which was
No, I haven't got to the Paribas yet.
Yeah, life policies based in the USA.
Sorry, Reusa was life policies in the USA, was it?
Life policies in the USA, my lord.
Thank you. And was that also the case for Invest US?
Invest US with the properties, my lord, in the USA.
Thank you. And the Paribas bond was on a residential building in the region of Brazil known as Paribas.
That's right.
Thank you.
So the commissions are in the order of a sixth or an eighth of the total amounts of the investments.
Yes. The commissions are set out there. The receipts of the commission are set out at page paragraph 167, and that obviously informed the making of the orders for interim relief.
In some cases, as much as 25%.
Yes.
Thank you. Sorry, I detained you. You were going
Not at
to
all,
take
not
us.
So I was going to take your lordships to the taking lordship, I think, to the Avacade, to the AA model, which I pointed out included the Black Star role, and then it's helpful if one take your lordship to page 173, because there we have.
Paragraph.
Well, I'm going to start at paragraph 180, which the judge describes as a good starting point. And this was an analysis which the FCA put in their opening, and which the judge accepted and adopted. And what it did was it broke down into 4 steps what the FCA said had taken place. So first step was a transfer out of existing pensions, which were usually occupational pension schemes, but sometimes personal pensions. Now, that's what we're calling step 1. Step 2.
I'm sorry to keep interrupting. Step 1, insofar as it involved transfers out of personal pensions as opposed to occupational pension schemes, would involve buying regulated investments.
It would
but the FCA didn't put its case on that basis.
It didn't.
Is that right?
It didn't, and I was going to explain that because it didn't do that. So because the majority of these transactions involved occupational pension schemes, and so they opened the case, and they set out their stall at the trial on the basis that what they were relying upon was steps 2, 3, and 4. So that's the transfer into the SIP, and then the divesting of cash from the SIP, and then the purchase of one or more of the investment products.
Thank you.
And the judge analysed this at paragraph 182, where he says that a person who acquires rights under a SIP, which is step 2 above, or who disposes of the existing rights under a SIP, step 3, in exchange for new ones, step 4, is involved in the buying or selling of securities, even if the new investments acquired, step 4, involve direct ownership of assets, for example, the ethical forestry or global plantations, and are therefore not themselves securities. And the same follows if the investment acquired at stage 4 is itself a security, e.g. a bond. So that analysis by the judge, which informed his view, was not least based in part on the guidance that the FCA had produced in the Perimeter Guidance Manual, and your Lordships will be familiar with that. It's not law, but it's certainly people will have regard to it, and it's reproduced in the authorities bundle, but the relevant extract is to be found in paragraph 184 in this judgment. And it's particularly the paragraph that says that when a member or his agent instructs the operator to buy assets of any kind, either from existing cash or from the proceeds of selling existing, then the member is converting his rights, and the judge agrees with that analysis, and he therefore took the view, which we now know has been revisited in Adams, that each of the steps 2, 3, and 4 involved effectively a regulated activity of a specified kind. And he explains in paragraph 186.1, explains why the FCA were not advancing their case on step 1. And the judge also says this at paragraph 186.2, that although for analytical purposes it's useful to separate the 4 steps, he thought that in substance, steps 1 and 2 are really 2 sides of the same coin, and step 3 and 4 likewise. And as far as the consumer was concerned, there were really only 2 steps: the decision to transfer into the SIP and the decision to use those funds once in the SIP.
And then he poses the question about whether it's a seamless whole, which he answers later that it is.
Yes. 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 So, having concluded that that not only the movement into the SIP, but also the movement in the SIP and out of the SIP to purchase any assets, regulated otherwise, was the selling of securities, the judge went on to consider, at paragraph 193, page 176, the page 177, paragraph 202, the judge set out our submissions that the Avacade companies, Avacade and AA, were merely introducers and providers of information, and that they were not able to influence the investor decision that was taken, and that in effect the investor decision was too remote from the activities of Avacade. And specifically at paragraph 206 of page 178, the judge dealt with our reliance upon Article 33 exception, and whether or not we were protected by the fact that it was with a view to the provision, that the arrangements with a view to the provision of independent advice, with independent exercise of discretion, and I'll come back to that when I answer the submissions in Article 33. The judge then reviewed the authorities relating to making arrangements, and he and I don't know how much assistance your lordships require, but he considered the judgment of Mr. Jonathan Crowe, Queen's Counsel, in the Inertia Partnership case, which was an Article 25.1 case, and which was relied upon by the respondents then and now as demonstrating that there's a wide interpretation of the words making arrangements. He then considers Mr. Justice Holroyd's judgment in Watersheds and DaCosta from 2009, which was a claim for fees, which was defended, amongst other things, on the grounds that the contract, the underlying contract for the services, was unenforceable because the unauthorised intermediary was engaged in regulated activity under Article 25 of making arrangements, and the judge rejected that defence, and we were submitting that in Watersheds and DaCosta the judge was adopting a narrower definition of making arrangements, which introduced the need for some degree of causality between the arrangements and the transaction. And then the judge referred to the court, your Lordship's court in 2016 in Simply Shaw and Personal Touch Financial Services, where Sir Stanley Bunton had described making arrangements as being framed deliberately wide. And finally, in this context, the judge also, before he delivered his judgment, had regard to what His Honour Judge Dyke said in Adams and Options at first instance, which, as your Lordships will recall, was a claim by an investor against a SIP administrator who, like the SIP administrators in the present case, were acting on an execution-only basis, following an introduction to them by an unauthorised introducer called CLP. And that related to the acquisition of store pads, an unregulated investment. And the investor in Adams and Option had claimed that CLP had been making arrangements and referred to Article 25. Pleaded case in Adams and Option was based on Article 25.1. And the Judge Dyke rejected the proposition that they were making arrangements in that sense, and emphasised the need for a causal link between the acts of arranging and of the transaction itself, and held that the steps taken by CLP were essentially administrative and were too far down the chain of causation. But significantly, and I don't know whether you want me to take you to the first instance judgment, but if one goes to paragraphs 123 to 124 within that judgment, and maybe I can take you to by reference to Mr. Johnson's judgment for efficiency. The Judge Dyke also considered the unpleaded alternative case, which was advanced by the claimant at the trial, which was based upon Article 25(2). And we say that what Judge Dyke said was that those arrangements should be construed in a similar way as in Article 25(1), so that a mere introduction wouldn't suffice, and the steps which were taken with a view to the transaction would have to be capable of satisfying what was described as a notional causation test. So that's an overview of the authorities that Mr. Johnson considered in Avacade, and helpfully, everything I've said, rather than having to go to the individual authorities, the relevant passages have been reproduced in this review of the authorities by Mr. Johnson. So he begins by referring to Mr. Jonathan Crowe, and these were the words which were highlighted by the judge and indeed by the FCC, by the respondents, that the word arrangements is, depending on the context, looking at paragraph 210 now of Mr. Johnson's judgment, capable of having an extremely wide meaning, embracing matters which do not give rise to legally enforceable rights. And also we'll see that in setting out the analysis, the judge refers in paragraph 5 of his, in subparagraph 5 of this part of his judgment, to paragraph 39 of his judgment, that the availability of the exception in Article 26 is essentially a question of fact. As a matter of causation, did the arrangements bring about the transaction, i.e. the purchase sale of the shares?
So where are you reading from?
I'm looking at the extract from Mr. Jonathan Crowe's judgment, which appears at paragraph 210 of Mr. Johnson's judgment.
Yeah.
And I'm looking at within that, there's some numbered paragraphs, although they're not separated out as paragraphs. And I'm taking your lordship to subparagraph 5 of paragraph 39 of the judgment of Mr. Jonathan Crowe, where he talks about the issue of causation there. So the judge in Mr. Jonathan Crowe in the inertia partnership LP actually treated this as a factual question and looked at the specifics of the introductions that had been made, potentially the purchase of shares, and drew distinctions between the different transactions. But to give an example of how he approached this, when he took out of when he suggested that there was no arrangement in relation to one of the transactions, he indicated there that a mere introduction was not a regulated activity. And I don't think there's anything between us on that. I think that it's not. There's nothing between myself and a friend that arrangements, making arrangements for Article 25 to be a regulated activity has to go beyond a mere introduction. In the Watersheds and Costa case, Mr. Justice Holroyd, as you'll see there at paragraph 214 of the judgment, stated that he was fortified in his conclusion that a mere introduction did not involve any violation of the general prohibition, by reference to, again, the perimeter guidance. And this time, that which he has quoted, that the activity of arranging, bringing about deals and investments is aimed at arrangements which have the direct effect that a particular transaction is concluded. He then, Mr. Johnson then reproduces my submission, which was that although Mr. Joseph Holroyd was there referring specifically to Article 25.1, that should be read also into Article 25.2, and that in the case of making arrangements, opposed to Article 25.2, there has to be an element of causality, and that what was being submitted here was that Avacade and AA were themselves powerless in bringing about the eventual outcome, and I have to accept that the eventual outcome that was being addressed at that point was certainly the purchase of the investment. So far as the point about the activities don't fall within the article because it's providing support at one party potential transaction only, that's not a matter that I'm seeking to advance. But what I do say is that that what is a feature of making arrangements is the need for there to be a causative nexus. So at the heart of my submissions upon which we've been granted permission in grounds 1, 2, 3, at the heart of that is our proposition that the judge in Avacade was wrong, and he adopted too broad a meaning of making arrangements, because we submit that there has to be a direct and instrumental link, which we say applies to both limbs of Article 25.
There's a difference between sub 1 and sub 2 in that sub 1, as I understand it, relates to a particular investment.
Yes.
But sub 2 doesn't. So somebody in your client's position can't say, well, we didn't have any control over which investments were bought, when it was perfectly obvious that investments were going to be bought. Indeed, that was the whole point of the exercise.
Yes, and I just want, and I will take your lordship to the judge's analysis on that, because he does seek to distinguish between the two limbs, between 25.1 and 25.2, and perhaps I'll come to that, because the judge provides his conclusions in respect to this, having referred to simply shore and personal touch finance mentioned, which is to do with arrangements.
So where are you now?
So the conclusions he comes to is take to page 182. Before I come to that, forgive me if I could just backtrack a little bit. Significantly, the judge considered the decision of Judge Dyte in Adams and Options, and it begins that at paragraph 219. I ought to say, because I'm at that point, learned friend in their written submissions draw attention to Lord Sumption's remark in a slightly different case involving FCA and asset land, where it was suggested that arrangements is a broad and untechnical word. But, Adams and Options, the judge, as I indicated, held that the steps that were taken out by CLP, the introducer, did not amount and qualify as arrangements for the purposes of Article 25(1) because they were too far down the chain of causation. That's a paragraph 2. That's summarised at paragraph 221 of Mr. Johnson's judgment, which is referring to Judge Dyte, paragraph 118. The judge then considered the claimant's alternative case, which was raised at the trial, which was that the arrangements fell within 25(2). And the Judge Dyte said that arrangements should be construed in the same way as in Article 25(1), and a mere introduction would not suffice, and the steps taken with a view to transaction would have to be capable of satisfying a notional causation test. And I draw attention to that because although your Lordships will be looking at Adams and Options in your Lordship's court, this issue concerning how coextensive arrangements are when used in 25(2) and used in 25(1), and the position taken by Judge Dyte, so far as I'm aware, hasn't been reviewed by your Lordship's court.
But you say the causative link is the same in 25(1) and 25(2).
Yes.
And in Adams and Options, they did consider the causative link.
That's right.
For the purposes of 25(1).
That's right. And for 25(2), and they said that, but 25(1) they did consider it.
Yes.
I mean, the court, your Lordship's court considered it, I should say. But the need for some element of contractual nexus and is in my submission still required when looking at the scope of the regulation and the activity that is regulated within 25(2).
And the expression you've used of a direct and instrumental link,
Yes.
Is that an expression of the causative test that we see in any of the authorities or in the statute? That's simply your formulation.
It's a formulation. I mean, as I say, we have references to chain of causation. We have references to notional causation test, and it's simply simply a formulation by Mr. McGarry and myself as to how we would provide the capsule for that. Thank you. Submission.
I mean, how do you get direct and instrumental link out of the words "with a view to"?
Yes. So the reference to "with a view to" is making arrangements, and it's looking prospectively, or as the judge describes it as inchoate. A person who's participating in the arrangements, which is the investor, then buying or selling. And ultimately, it therefore, though it's inchoate, like other matters which are inchoate, whether the operative element is that the person with whom who's participated in the arrangements is buying or selling a security. Now, the question may well arise in this case, in the light of Adams and Options and the Court of Appeal's disapproval of Mr. Johnson's analysis, and the focus being on step 2, which buying or selling of investments the judge had in mind. Because clearly, from the point of view of both the issue of culpability, from the point of view of the way in which the case was opened, from the way in which the judge makes his findings in his judgment, the iniquity, so to speak, that we're dealing with here arises from the back end and the purchase of the investment, risky investments. And the question is whether if that's what the judge is looking to, how far that appears down the chain of causation.
Doesn't Article 20, Section 26 help? I mean that refers only to subsection 1.
Article 26, yes.
And means that if something doesn't have a causative effect, or wouldn't have a causative effect, then it's not caught by
That's right.
subsection 1. But the same thing doesn't apply to "with a view to."
No.
So why should they be treated the same?
There's
in logic. I mean, before we get on to what anybody else has said.
Indeed. Well, I can put it this way, that in the case of Article 25(1), we're dealing with a single transaction. It's expressed in those terms. It's a single transaction. So all that is under consideration is making arrangements which involves a single transaction. And the intention of the Treasury or Parliament, Treasury, to treat as a regulated activity the criminalisation of a single transaction was that the transaction had to take place, and even if it did take place, it had to be linked to the arrangements.
Yes, I got that. But we're talking here about the other
Yes.
matter under 2.
Yes. So
But why, if there had to be the similar causative link, is there not a regulation of or similar sort to 26 that deals with 25(2), maybe making allowances for the fact that one's not looking for a single transaction but looking for an investment.
Well, if one's not looking for a single transaction, but one's looking, for example, the example we gave was repeated transactions. That in those circumstances, it may be thought that providing a get out for the unauthorized person, based upon the fact that the transaction didn't occur at all, would be to impose too low a threshold for the regulated activity. In other words, too high a threshold for the regulated activity, because what was clearly intended was, because it's inchoate in nature, that must be what you're trying to achieve. You're trying to achieve that transaction, and you're going to be caught irrespective of whether the transaction actually occurs.
Well, might it be said that 25(2) is wider in the sense that what is objectionable and needs to be regulated for the purposes of consumer protection is not only arrangements which do result in a deal, but attempts to persuade people to enter into regulated transactions, and that in subsection 2 it has its own causative phrase, which is with a view to.
Yes.
In other words, the degree of connectivity or causation that one's looking at for subsection 2, or subparagraph 2 of the article, is simply whether the intention is that the arrangements should result in a regulated transaction.
Yes, I mean, I would respectfully adopt what Lord Justice Popplewell has said. I think that is also why without aligning the two, which is something I'm seeking to avoid doing, the requirement for there to be some form of notional causation test or some form of causal connection between the arrangements and the transaction, or the intended transaction, is what also underlines the judgment from Judge Wright in the first instance in Adams and Option, and we would commend that to the court.
But can I just see where we're going on this? If you'll forgive me.
Of course.
The position after the judgment in this court in Adams is that we put on one side for the moment the underlying investments, and we look only at the transfer into the SIP as that which is the regulated activity with which we're concerned.
Yes.
And it is the effect of your submission that on the judge's findings, what Avacade and AA did was not with a view to the transfer of the occupational pensions mostly into SIPs.
Yes. In fact, I go further than that. The judge explicitly states in his judgment that the real purpose was the ultimate acquisition of the investments from which Avacade and AA would receive their significant commission.
Well, he says it's both. He says it's all essentially seamless because persuading them to enter into the SIP is part and parcel of the operation of persuading them to enter into the underlying investments in order to earn their commission.
You can't have one without the other. The fact that the second stage may not be regulated doesn't mean that the first is.
Yes, I understand that, and that clearly is two things that emerge from that. One is that one's got to look at the judge's findings and also look at the commercial reality of this, because this was brought by a regulator against our clients with a lot of publicity on the basis that people had lost substantial sums of money from reckless investment in unregulated products. And without any disrespect to my learned friends, the case was opened on that basis, and that was the purpose of the four-step approach which the judge adopted. And it's also the basis upon which Mr. Justice Houseman has made orders in millions of pounds against my clients. And although it's right to say, as Lord Justice Jackson says, that one can take an approach to this case, which is one looks not only at the step of entering into the SIP, but one sees that as part of a series which leads ultimately to the reckless investment in the pots. First of all, my clients are no longer in control of the situation after it has gone into the SIP. And secondly, we are, in our submission, getting into the territory whereby the activities of Avacade and AM might be said to be too remote from the point at which the substantial loss occurs. If one's only dealing with the gain to Avacade from the movement into the SIP, which is minimal, and at the point of entry into the SIP there's no actual loss to the consumer.
But you're not tackling the point that's being made, and was made by the judge, which was that this is a seamless whole. And once it is a seamless whole, a finding which it's impossible for you to challenge before us, and indeed is not challenged, then the profits that are made from the seamless whole, it's of no consequence whether the profits are made at stage 4 or stage 2. The fact is, the whole thing was an activity, an arrangement, which led to your clients taking a large commission. And it's part of it is a regulated activity, and you weren't regulated, and that's what happened. I mean, what is your answer to that?
Well, my answer is to compartmentalise it.
But you can't compartmentalise a seamless whole. You have to challenge the finding that it was a seamless whole, which you have not done.
Well, it's perhaps in that context that particularly in the light of the emphasis now being placed upon step 1, in the light of your Lordship's Court's decision at Adams and Option, that some of the issues that I'm going to come to, just for example, if one takes for example the Article 33 exception, and if one were to have regard to the role played by the SIP providers, SIP administrators, who are not merely rubber stamping, they're accepting the SIP, they're assessing it as a SIPable product, and they are accepting the transfer into the SIP. And even if they're acting on an execution-only basis, they still owe duties of diligence and duties, execution duties, to their customers. Now, if one was approaching this case, and if the FCA had approached this case solely on the basis that they were relying upon step 2,
they would have done it differently, but it's an entirely technical point. What my lord, I think, was asking you, and both of my lords really, and me, is how does this compartmentalisation, this challenge in your grounds of appeal, add up to a row of beans? Because whilst the FCA and Mr. Justice Johnson might well, had they known the law as enunciated by this court in Adams, treated the matter slightly differently, the fact is that on the analysis of that judge, you cannot get out of the finding that it was a seamless whole devoted to getting the commissions at the end, the fact that that bit is not a regulated bit doesn't affect you falling within Section 25(2). End of story. Now, I mean, it's all very well to sort of dance around that conclusion, but we need to have from you, in very clear terms, in order that we can understand it and Mr. Vinyl can deal with it, what is your answer to that point?
Well, it is a matter of characterisation, whether it's a seamless whole or whether it's not. It is a matter of
whether it's
a seamless whole, whether you're dealing here with a chain that is seamless or.
Well, that's a finding of fact made by the judge.
Yes, but he was making it
on the evidence.
But through a different telescope, because he was looking at the horizon and at the exit out into the unregulated product, rather than looking at it, rather than the telescope, looking at it rather as the microscope, looking at the first step and asking himself, if that's the regulated activity, to what extent does that regulated activity fall within? To what extent does that movement into the SIP fall within the Article 26, Article 25?
I mean, you have 4 grounds of appeal available to you, and they are very specific, and they relate in the first 3 cases to arguments about causation, which we have put questions to you, which, being perfectly frank, I don't think you've answered, and they relate to Article 33, to which you will no doubt come as a specific point. But there is no challenge to the finding that it's a seamless whole, and therefore it is a seamless whole in this court, and that's the beginning, the end of it. So, you know, what is your case? How do you get round these findings? I mean, okay, I understand the causation point. I don't quite see how it takes you home, but I understand the point at least.
Well, if I take your lordship to the way that the judge expresses this question of the seamless whole, if I can take you to those passages that where he does deal with it. Can I just take your lordship through those, if I may?
The question is posed in paragraph 186.
So the judge frames the questions, if I may, paragraph 231, page 187.
Sorry, 200 and...
Page 187 of paragraph 231. And then he looks at the facts, and I think paragraph 234 is relevant here, because what he says is that it seems clear that the real prize for Avacade was an investment in one of the products from which you could earn a commission. And the attraction of sourcing consumers who would agree to transfer their existing pension pots into a SIP is again obvious. And there would be the wrapper through which it would happen. So I think that's really where the judge is looking to the SIP as being a vehicle for the purchase of the products that are largely unregulated.
And the judge is explaining that the pension wrapper is an essential part of it, because that's how you're going to persuade the customers to invest their money, because it's coming out of a pension and going into another pension. These aren't non-pension pots. So that the SIP wrapper is an essential ingredient of persuading people ultimately to invest in something which provides a commission.
Yes. So that it doesn't lead ipso facto to the purchase of the product. There's still a decision, investment decision being taken once it's entered, once the consumer's entered into the SIP.
I understand that, and I understand why you say that that might be an important consideration on whether there's a sufficient causative connection between the arrangements and the final investment. But we're not on that point anymore. We're on whether there's a sufficient causative connection between what was done by your clients and entering into the SIP.
Yes. And
well, so where does your point that there's no influence over the final investments go on that question?
Well, only that the judge makes it clear that his real concern, and I could accept, I probably have to accept, that in the light of Adams and options in the Court of Appeal, that the movement into the SIP is a step which is regulated activity if my clients had made arrangements for that, with a view to that happening.
Yes.
And there was evidence on which the judge was able to conclude that the steps taken by Avacade and AA were potentially steps that would constitute arrangements for these purposes. But we're not concerned with mere technical breaches of the regulations. And so even if I were, and maybe, that I have to make that concession in relation to the movement into the SIP, depending upon the findings, based upon the findings of Mr. Johnson. But it doesn't follow from that the case that was being advanced and the case that my clients had to meet, and in particular when we come to look at the sanction of the financial redress that's been ordered by the interim orders, that this can be approached purely in terms of the technical breach and the regulations in step 2.
Well, why not? I mean, if there is a technical breach, then that is what the FCA sought to establish, as I understand it, against you. So what are we doing here if we're not seeking to establish whether the judge was right to find breaches of the legislation?
Because the target in the lower court, as the judge described, the desired endpoint in the real prize was step 4.
Yes, we know that, but the target, as I've been putting to you for some time now, the step 4 was a part of a seamless whole, as the judge found. And step 1, step 2, was a regulated step which you were not regulated or permitted to undertake. And as a result of that, as a part of the seamless whole, all those millions came out into your collective pockets. I mean, we have to have some commercial reality about this case. You know, I mean, as I sort of understand your argument, it's a sort of technical salami slicing that you want to undertake in the hope that we won't see what the reality was. But the judge, in 400 paragraphs, has told us in very measured terms the reality of this activity. I won't denominate it in a pejorative way. Now, you know, you need to, if I may respectfully say so, to succeed on an appeal in this court before 3 judges who've read these papers and do understand what's going on, You need to get your screwdriver into Mr. Johnson's judgment. If you can't, then, you know, appeals are not very promising. And the only screwdriver that you've got in your hand relates to causation and Article 33. And at the moment, I don't see, and I think my Lord started asking you about this at about 10:33, I don't see where we're going, how you can possibly get to the ultimate conclusion that the judgment is unsafe and wrong, even despite Adams blowing a hole in the middle of it.
I do recognise the challenge.
Right. Good. Well, that's a good start.
And I can only advance without becoming repetitious.
Yes.
Which I want to avoid.
Mm-hmm.
That the words "with a view to."
Yes.
That it's artificial in the context of this case to treat "with a view to" as being movement into the SIP. It's
Hang on, just say that slowly. It would be artificial to treat the words "with a view to"
as being a reference to entering into the SIP. Because on the judge's finding, the real motivation was not with a view to entering into the SIP, it was with a view to purchasing products.
Well, it was with a view to both, wasn't it?
Well, that raises the question as to whether or not that's entirely fair, because what the judge says several times is that the real motivation and what was the driver for this was with a view to the back-end commission. And I don't think I can take it further than that. It seems to me that it's whether with a view to is in the context of both the way the case was opened, presented, and the judge's findings, whether it's fair for my clients to be exposed to the financial consequences of both the findings that they were knowingly concerned and the interim remedies.
So, I mean, just to try and stand back from this, your salami slicer asks us to say that your clients may have made arrangements with a view to the clients entering into the SIP, but that is part of a different and distinct and divisible transaction from their having made arrangements with a view to the consumer entering into the purchase of trees, and that second transaction is not a regulated transaction, and therefore we should hold that you get off effectively as not having done anything wrong, but materially wrong. I mean, you would probably accept that you may have done something wrong for step 2, but you haven't for step 4. I mean, it's
My Lord's expressed it. I can, as I said before, I can't over refine it, but that is a matter of characterization.
But I mean, where do you get? I mean, how does that found itself on the judge's judgment? That's my problem. I think I've said that. At least we now know, Mr. Barclay, that your salami slice has only made one incision. It's basically 2 great chunks of salami. Salami slice 1, which is stage 2, and salami slice 4, which is the second one.
Yes.
Yeah. Okay.
I mean, again, in the light of the observations made so far, it may be that I can bring in a couple of other issues which probably are going to be also dependent on this issue, because it may be relevant to additional grounds. And
yes, by all means. I think we've got the submission on causation. I think you've still got to deal a little with Article 33.
Yeah, I'm going to deal now with Article 33, and I want to also deal with Article 29 as well, although that doesn't form part of these grounds.
No. Well,
but in my submission, it will be helpful whilst we're focusing on this to look at that as well. The Article 33 point. There was a issue over the construction of Article 33, and I'm not sure that how productive it is to look at that in light of the observations made so far. But can I put my case on how I would reformulate Article 33 now in the light of the exchanges that have taken place today?
I mean, don't be thrown off course by the exchanges. No. I'm just putting questions to you to which we'd like an answer, but it's you. I need to hear all your submission.
I understand. So the judge deals with the Article 33 submission.
Which paragraph?
So it's paragraph 287. Page 201. I suppose Your Lordship may want to deal with the construction point, even though so I should take you really back to paragraph 251 on page 192.
Well, that's right.
Construction.
We start at 2:30, don't we?
Yes.
Sorry.
No.
Well, the construction point is the only point on which you've got permission, isn't it, on Article 33? So if you're telling us it doesn't matter, where does that take us?
Well, we are reintroducing Article 33 in the additional grounds.
All right.
And therefore, because it's linked to what we've been discussing, I thought you might allow me the indulgence of speaking more broadly about Article 33, particularly as we're raising it in our additional grounds. It may be that the point is going to be answered in much the same way as we dealt with so far, but I feel it's helpful to just deal with that. So the construction point, unless was whether or not extent to which the or was disjunctive and whether or not the independent exercise discretion in relation to investments generally, or class of investments, or whether simply make an introduction to an independent advisor or independent advice. So this is with a view to the provision of independent advice, whether or not that provided the exclusion, and or whether, as the FCA suggested, that the independent advice had to be, in order to achieve the exemption, it had to be in relation to investments generally, in relation to classic investments, because otherwise the protection given to the consumer would be lower. Okay, that was the point of construction, and the judge preferred the construction proposed by the FCA, but he formulates the question on page 231 where he suggests that one of the questions is whether the arrangements in the form of introduction with a view to the provision of independent advice, so that Article 33 would apply. And page 192, page 251, the judge says that he's satisfied that the introduction was not an introduction with a view to the provision of independent advice.
I'm so sorry, I missed the paragraph.
Paragraph 251.
Thank you.
So the judge was satisfied that makes the finding that the introduction was not an introduction with a view to the provision of independent advice or the independent exercise of discretion. And part of that analysis was to consider what's the meaning of the words "with a view to," and that required an assessment of the purpose of the activities. What were the activities for? What end result were they intended to achieve? And the judge says at page 253 that the real purpose of the arrangements was to bring about a situation in which the desired investments would be made and the commissions earned. And that's the arrangements looked at as a whole. And it seems to me that any of the individual steps looked alone, if the overall context is borne in mind, and he says that it must be correct that the court of which any individual step takes place must inform its overall characterization. And it's difficult to assess the true purpose of any individual step without looking at the overall matrix within which it occurs. So that very much was the salami slicing being effectively disapproved of or looked at disdainfully by the judge. He was looking at it in broader terms. And he says in paragraph 254 that Avacade's own commercial interest as a business, fair to say, was with a view to bringing about a situation in which the existing pension funds are liberated and then invested in products from which Avacade might make a commission. And he says that applies really to all the other steps, that one's got to look at the overall purpose. So,
could you just, when we're considering this, remind us, what did your clients say they were being paid for?
They received their commission. They received payment from the companies in which the investment was taking place.
Yes, I understand that, but what were they being paid for? Why were they being given these commissions?
They were being paid, I think, essentially as introducers.
But how does that sit with the judge's findings? That was their case, but
I'm not. Again, it's difficult, as I said. It's in my submission on a fair reading of the judgment. I know that that I'm back to perhaps the suggestion of looking at this in compartments, but in my respectful submission, what the judge was approaching on the basis, wrongly as it turns out, that the whole thing was with a view to a transaction taking place at the back end, which was a regulated activity. And so when he was looking at with a view to, he was looking with his telescope to the point in time when the investment was purchased.
That's what he found in perfectly clear terms to be the whole point of your activity.
Yes, and then the question is whether that engages the with a view to in the context of Article 25.2.
Well, I mean, the problem with that is that if you look at 254, which you specifically referred to, he says, looked at in context and bearing in mind Avacade's own commercial interest as a business, it seems to me fair to say it is with a view to bringing about a situation in which existing pension funds are liberated, stage 2, 1 and 2, and then invested in products from which Avacade might make a commission, stage 3 and 4. And that is a seamless whole.
Yes, it's characterised that way by the judge,
Well, that's you've got to appeal that.
Yeah,
Unfortunately, when judges make findings of fact, you to win on appeal, you have to get permission to appeal, and then you have to succeed in showing the judge was wrong. And at the moment, I don't see how you can do that without a ground of appeal for which you've been given permission.
Well, save that. That we still want to maintain that the words "with a view to" has to be linked to the regulated activity. And
right, in what? In section 25(2). We're back to 25(2). Yeah.
And if the regulated activity is the entry into the SIP alone, then that doesn't meet the mischief which this whole claim was designed to.
Why not? If you persuade people to substitute safe pensions for risky pensions, what could be more mischievous than that?
Yes, but it's the again, I don't want to start becoming repetitious. What I say is that once it has moved into the SIP, so if one isolates that, and I know that's
so it gives you a sort of cordon sanitaire behind which you can earn your commissions. Nobody can get at you.
It provides, if there is, as in the case of the SIP providers, you've got an authorised person who is in the who is actually has the investor as his client at the point at which the unregulated step takes place.
I understand the submission.
Well, I suppose your point, putting it at its highest, is that making arrangements with a view to a consumer buying or selling investments relates to regulated investments. At its highest on the current law, this was making arrangements with a view to a person selling regulated investments. It wasn't arrangements, well, with a view to a person buying regulated investments, because they weren't, and therefore any relief, at least, that the FCA can get is based only on the breach of the regulated activity.
Yes.
And there was no loss caused by putting it in the SIP.
Yes, I mean, I'll come to that on the second appeal. That's what the second appeal relates to, and it's the words "as a result of." We'll see that within the section as to whether or not the context of this, the losses or the gains, are as a result of the contravention.
But the problem with that is the seamless whole.
It depends how far that goes, how far that modelling goes in the context of matters which have significant consequences for the person, the unauthorised person, both in terms of potentially criminal sanction, both in terms of the financial consequences. The question is what in fact is the scope which Parliament gave under the Financial Services Markets Act to recover losses or gains.
Well, is there a further causation requirement in the section that allows there to be an IR? Is it called IRO?
Yes. I took
Which section is that? Just remind me.
Section 386, I think. Let me just.
382.
382. And
profits have accrued to him as a result of the contravention.
Yes.
Suffered loss as a result of the contravention.
Yes.
So you say the contravention here can only be stage 2. So they haven't suffered loss as a result of putting it in the SIP. They've only suffered loss as a result of something that's not contravened, and therefore that's it. In a seamless whole, you say, well, that's just a device. You can't lump it all together.
It has to be as a result of the contravention.
And it's not.
It's not.
That's one of your additional grounds, is it?
Yes, I'm. It's in the application. I'll come to that. I'll have to check precisely how it's formulated, but certainly.
Well, can we look at how it's precisely formulated so we can see? So where do you want to look at?
Just have a moment whilst my learned June is just looking for it, but it would arise under the second appeal.
Mm-hmm.
It's certainly stated, if one goes to the appellant's response document of the 30th of June 2021, you should recall there was a flurry of different exchanges of submissions.
Is that the one that came in yesterday?
I'm looking at the 30th of June response.
Yeah. Not yesterday.
by the appellants to the respondents' written submissions on permission and stay. And paragraph 16 of that, I'm reading from it, it says, in addition, the change in approach of the Court of Appeal raises difficult questions as to the correct approach to relief.
I'm terribly sorry, I'm not quite clear which document.
I'm looking at a document which is dated 30th of June 2021 and which is described as the appellant's response to the respondents' written submissions on permission and stay applications.
Appellant's response to new grounds. What paragraph is it?
16.
Yes,
In addition, the change in approach.
yes, that's it.
Got it.
So it reads, in addition, the change in approach.
Yeah, we read it, but how does that translate into a ground of appeal?
Well, it doesn't. I was mistaken. There isn't, in fact, at this stage, formulated an application for additional grounds in relation to the second appeal. But I would invite your lordships to consider it, and perhaps over the luncheon adjournment I can put that into a formulated grounds as well.
Not a very satisfactory way of dealing with it, is it?
No, I accept that. I mean, we'd identified the issue, but I accept that what we haven't done is formulate an application to extend the grounds on the second appeal.
Yeah. Well, where do we go now?
And so perhaps I can just deal now with the Article 33 exception, and again the judge did not accept that the arrangements would be with a view to the investors receiving independent advice, or with the
Sorry, I'm finding it hard to hear.
Sorry, the judge did not found that it was not the case that the arrangements or the introduction was with a view to the investors receiving independent advice, or the exercise of independent discretion. And so he rejected the submission that the appellants, or that Avacade and AA could rely upon the Article 33 exclusion.
As a matter of fact.
As a matter of fact. That was partly based on the fact that both in relation to Cherish, one of the IFAs, and in relation to Blackstar, he found that that they weren't providing independent advice, and that wasn't, the introduction wasn't made with a view to the exercise of independent advice.
You found that the introduction was because there was an arrangement whereby the money was going to be invested, and then there'd be a commission flowing backwards.
Yes.
That's the starting point, then, isn't it?
The starting point was that there was a mechanism introduced. Certainly, partly under the regime of the cherished regime under Avacade, and then AA used Blackstar, whereby there was some role being played by independent financial advisors. It doesn't matter because the judge in the event found out that was illusory one way or the other. But what the judge also considered, which is what I would like to develop now, is that the introduction, particularly in relation to specifically in relation to the SIP transfer, which is the only regulated activity, was with a view to the independent exercise of discretion. In this case, I mean by the SIP provider. And the judge dealt with that submission at paragraph 280 at page 199. And again, I emphasised to him that within the context of the regulations associated with treatment of consumers, that the SIP providers, even in the context of execution-only services, still owed obligations under FCA principles. And I'd referred him to an authority to that effect in relation to Barclay, a company called Barclay Burke.
I'm sorry, so I can understand this. This is ground 9.
Yes.
Could we just look at ground 9 to see exactly
yes.
what you've been given permission to argue? I have it in the electronic bundle at 17, page 17. Paper bundle, page 30.
Yes.
So this is to do with construction of 33C.
Yes.
And what the judge said about it was at 230.10.
Yes.
Well, would you mind if we went to 230.10 so that follow the argument?
Yes, so the construction point really begins at and 237 really at page 186 rather than 10, and it focuses on the precise language. So the point is one of syntax. So and it relates to the extent to which the operative provisions are controlled or qualified by the concluding words. So the two rival readings are set out there. The FCA's reading is that the introduction is made with a view to the provision of either independent advice or the independent exercise of discretion in either case in relation to investments generally or in relation to any class of investments to which the arrangements relate. And it's a narrow point, what the defendants were contending for, that the introduction is made with a view either to independent advice full stop or the independent exercise of discretion in relation to investments generally, in relation to class of investments to which the arrangements relate. The practical difference, and I'm not sure that it now has any real application in the light of everything else we've been discussing, but the difference between the FCA and the defendants, which may be simply a point of principle now, rather than a point of any real application, is how high the threshold is to achieve the Article 33 exception. The FCA were placing that higher than the defendants, because the defendants said once you have any independent advice, it doesn't matter whether independent advice does not have to relate to investments generally in relation to any class of investments. So if the independent advice, for example, related to suitability, for example, or related to the that one could, as the judge says, there could be one investment only, so you're not discussing investments generally or a class of investments. You've only got the one product in scope, so that might
that would suffice for you.
Pardon?
On that
yes.
reading, it would suffice for you. So you take your money out of one pension fund, you put it into a SIP, and they only talk to you about one investment. Well, what's going to happen then? The money's just going to sit there uninvested. Choices between it sitting there uninvested and it being invested in a single product.
Well, there's no doubt that the judge, in preferring the FCA's construction, was having regard to the fact that this was a safeguard to investors, with non-authorised persons looking for profit. And as I say, in the context of this appeal, although we've been granted permission to decide a point that clearly is there to be determined, if your lordships wish to do so, because it's not been subject of any other judicial determination other than that of Mr. Johnson. But I'm not sure that it's actually going to afford me a great deal of assistance in the overall scheme of this case. What I do
let's
say,
not waste too much time on it then.
what I do say, however,
Yes?
what I do say, however, is that once one has regard to items and options in the Court of Appeal and identifies the regulatory step, the step that is controlled, as being the entry into the SIP, the focus then becomes the SIP, then the submission that I was making, which forms part of my additional grounds in relation to Article 33 being relied upon in connection with in relation to the SIP providers, becomes, in our submission, far more important. So if I can just make those submissions perhaps before we come up to the luncheon adjournment.
And if I understood correctly, that the new ground is that the SIP provider exercises an independent discretion by deciding whether or not to permit the client to enter into the SIP. That's the bit of Article 33 you say is engaged.
Yes, because we're concerned with that regulated step.
Right. And the judge dealt with that.
Judge deals with it, and
just remind me where that is.
yeah. So it starts at paragraph 251 at page 192. Where he talks about what was the purpose, and then
But a lot of this is focused on whether there was independent advice from the IFAs in each case, which is no longer the point you're on.
yes.
The point about whether the SIP provider exercises the discretion.
Well,
Forgive me, it is there somewhere.
It is at 275 on page 198.
Thank you.
It's where he specifically deals with the role of the SIP providers.
Yes, thank you.
And he summarises my submission there at page paragraph 275.
Yes, but that's mostly addressed to whether they're exercising a discretion in relation to the underlying investments, which again isn't the point you're on now. The point is whether they're exercising a discretion in deciding whether or not to accept the SIP.
Yes.
And he does deal with that specifically somewhere, doesn't he? Where's that?
Well, so first of all, he summarises my submission that it was more than a rubber stamping exercise, and then he says at page 280, Roman 2. So I think what Lord Justice Popplewell has in mind. The terms of engagement gave the SIP some discretion to decline to accept the investments.
No, that wasn't what I had in mind, because he's still on the investments there.
Well, it wouldn't be the role of the SIP trustees, it would be the role of the IFA.
Well, save that. The argument being advanced was that even at the point of entry into the, don't forget, it is the case that companies like Liberty, SIP, were well aware of what was taking place in terms of the model. They knew exactly what their customers were coming into the SIP for, and although Liberty SIP and the other SIPs were not themselves parties to the proceedings, there was evidence about the role of those SIPs, and it's not a case, for example, that we're dealing with one single one-off transaction by a SIP provider who doesn't know what this relates to. In fact, it was because of, I don't want to trespass into the evidence, but it was because of FCA pressure about the introduction by unauthorised persons, such as Avacade, that put Liberty SIP under pressure to effectively cease trading and cease the arrangements that they had with Avacade.
Well, maybe
we'll have to come back to this after the short adjournment, but can I just tell you what I'm going to need some help on when you do come back? As I understand it, following Adams, what we're concerned with is the client entering into the SIP with Guinness Marne or Liberty. And for Article 33 purposes, one's concerned whether the arrangements that were made by Avacade and AA were with a view to that SIP provider exercising a discretion in relation to the entering into of the SIP.
Yes.
So it's really a question of whether which I thought was your argument, does the SIP provider exercise a discretion simply by deciding whether to allow the client to enter into the SIP or not?
Yes, but if he knows, again, yes, but one has to have regard also to the. One can't look at the seamless whole, or however you want to look at it. At this point, ignore that. The SIP provider, in exercising his obligations to his client and acting in his client's interests, can decline to accept the SIP. He can decline to accept the transaction on the basis that clearly that's prejudicing the interests of his client.
But by the transaction, you mean the underlying investment instruction?
I'm talking about the moving into the SIP. Moving into the SIP, if the position is that the movement into the SIP is a step towards, if one goes with the argument, moving into the SIP is a step towards ultimately buying trees and unregulated investments, and bearing in mind that we say that there is some element of diligence that is required on the part of the SIP provider, and it's not merely a rubber stamping exercise when they accept the SIP. Although I'm dealing with mechanically with the acceptance of the SIP, I say that is still the independent exercise of discretion.
All right. Perhaps when we come back at 2 o'clock, you could just formulate it so I can write it down. What the exercise of the discretion is, you're saying?
Yes.
It amounts to. Thank you.
very good. 2 o'clock.
All right.